matter of Green v. Dutchess. Counsel.
Good afternoon. May it please the court, excuse me, Dustin Brockner on behalf of the Workers' Compensation Board. May I have 2 minutes for rebuttal?
You may have 2 minutes.
Thank you. For 100 years, a non-schedule award terminated when the worker died for reasons unrelated to disability. The deceased worker was not entitled to any further benefits, nor were there beneficiaries. The decision below disrupted this century-old understanding.
Counsel, doesn't if we adopt your interpretation, doesn't that reinstate this different treatment between the SLU and the non-schedule awards that the legislature clearly was trying to eliminate?
No, Your Honor, and for two reasons. First, there's no indication that the legislature, when it was imposing the caps in 2007, because prior to that, I think it's undisputed that there were no way to possibly calculate posthumous non-schedule award. So the question becomes, what did the legislature intend in 2007 when it imposed a maximum on the, basically a ceiling on the maximum number of benefits a worker could receive? And the appellate division looked at that ceiling and gave it a different function, that it was a way to create for the first time, calculate and guarantee posthumous non-scheduled benefits. But there's nothing in the text or legislative history of the caps to suggest that the legislature wanted the caps to serve that function. First, we could look at the text of the caps. It says compensation shall not exceed a certain number of weeks of benefits. Caps are a ceiling, a limit on the maximum number of weeks a worker may receive, provided that they satisfy the ongoing requirements of 15.3W.
But then what about 15.4 though?
Your Honor, if you look...
Aren't we bound by that plain language? There's no distinction amongst awards.
Your Honor, if you look at 15.4 in isolation, it's plausible to read it as affecting both schedule and non-schedule awards. But there's several reasons why that reading fails. First, like any other statute, the workers' compensation law's interlocking provisions have to be read together. And when you read 15.4 in conjunction with 15.3, which is a provision that 15.4 refers to, it becomes clear that non-scheduled awards in particular terminate upon the worker's death. That's because Section 15.3W imposes two requirements on non-scheduled awards: continuance of disability.
Why not just apply it and let the legislature change the statutory language if that's what they meant?
Because there's no indication that the legislature intended for 15.4 to operate in that manner. It was enacted over 100 years ago, around 100 years ago, for a specific reason to apply to schedule awards. And in that century, there was no court, neither the court nor the board had ever even suggested it possibly could affect non-scheduled awards. So just continuing to apply it as it's always been understood means continuing to recognize that 15.4 affects schedule awards only, and that flows from the fundamental differences between a schedule award and a non-schedule award. Schedule award is fixed for a set duration of benefits. A non-schedule award, schedule award, therefore, it's a guarantee, it's an entitlement. A non-schedule award is not doesn't guarantee any benefits to the worker.
And what's the language in 15.3W that takes away the guarantee aspect of it? Is it wage earning capacity? Is it?
It's two provisions. Well, first, it doesn't take it away. It's that it's never offered in the first place.
Never put it in.
Yeah, exactly. So, and the legislature clearly knows how to guarantee permanent partial disability benefits. It does that in schedule awards. It says an award shall be a certain rate for a fixed number of weeks according to the statutory schedule. There's no analogous language in the provision governing non-scheduled awards. It says instead that the disability payable during the continuance of the disability, so if the disability no longer continues, such as when the worker has died, no benefits are payable. And even in addition to that, it is a function of the disability. To calculate a rate of a non-scheduled award, you need to know how much the disability has impaired the worker's wage earning capacity. But where workers died, for reasons unrelated to the disability, that disability never no longer can impair their wage earning capacity.
Just to confirm, a schedule award is payable in full at the time it's made, if that's an election that's taken, isn't that right?
That's correct, Your Honor.
And that's not something that would apply for one of these non-scheduled awards? They're payable in increments over weeks?
That's correct. They're periodic payments, Your Honor.
And do the, just to clarify, is your position that the benefits might actually fluctuate during the life of the claimant?
That's exactly right, Your Honor. They may fluctuate, they may be suspended entirely. They are not, and that is the fundamental feature of the non-scheduled award. It is not an entitlement, it is conditional, and when a worker has died for reasons unrelated to disability, they can no further benefits can accrue, and thus the award terminates. And if I may just return to the language of 15.4, I think what it refers to is existing awards, under awards that are still in existence. And so for a scheduled award, that's a guarantee. It's a fixed number of weeks of benefits. Its existence doesn't depend on the worker's life and can continue upon death. By contrast, a non-scheduled award's existence depends on the worker satisfying ongoing conditions, and therefore the award no longer exists upon death. And may I use just an example? Say a worker receives a scheduled award, guarantees her 100 weeks of benefits. She gets her 100 weeks of benefits. They're paid to her. There are no further benefits, and the award the scheduled award is terminated at that point. If that worker then dies for reasons unrelated to a disability, if that surviving spouse tries to say 15.4, hey, it says pay me under 15.3, the response would be, there's no award in existence. There's nothing, no further benefits have accrued. There's no further benefits that can accrue. The award no longer exists. And that's the same logic that applies to non-scheduled awards. Once a worker
So
can...
is that another way of saying, or maybe this is not what you're saying, so I'll just ask, is that equivalent to saying it's not vested, it's contingent throughout the life of the claimant? Till they reach the cap, of course.
It is a contingent award, absolutely. A scheduled award is guarantee, a non-scheduled award is not.
So
And
the
that's
SLU
that fundamental
is vested and the non-schedule is contingent in one way or another.
Yes. That's right, Your Honor. And also just returning to the caps for a moment, again, there's no indication in the text or legislative history to suggest the caps were a way to create a entitlement to non-scheduled benefits posthumously, and in fact, that'd be contrary to the overall legislative context. The caps were, as this court has explained, a concession to insurance carriers. One of the animating purposes was to reduce costs, and the appellate division's ruling is in tension with that purpose. It would increase costs, and on top of that, the caps did not displace the long-standing and ongoing requirements imposed on non-scheduled awards that we've been discussing. And if the legislature wants to guarantee permanent partial disability benefits, it knows how to say so. That's what it said for scheduled awards. It has not said the same thing for non-scheduled awards, and if it would like to provide the board with a way to calculate posthumous non-scheduled benefits, it can say so. It hasn't done so. And there's no indication from any of the history of 15.4 or the text of 15.3W to suggest there should be there are a way to calculate posthumous non-scheduled awards.
Thank you, counsel.
Thank you, Your Honor.
If it please Your Honors, I'm Ralph Magnetti from Cherry, Edson, and Kelly, representing the appellant, Dutchess County BOCES. I guess to pick up where Mr. Brockner left off, the first issue we have to deal with is whether the plain language of Section 15.4 compels that non-scheduled awards and scheduled awards be made in the same manner. Prior to 2007, that wasn't taking place, and we have to remember that a statute must be construed as a whole, and its various sections must be considered together with reference to each other. So if you look at that case of ACE Fire Underwriters versus the Special Fund, it dealt with Section 29, subdivision 5, which said an employee or the employee's dependents could make an application for a non-protunct order. It didn't say that the carrier or anyone else could make such a request, but this court held that the carrier in that case, who had given consent to the settlement, but then was unable to get consent from the special fund, brought the proceeding to get non-protunct consent to the settlement against the special fund. The plain language was not followed directly because they took into account Section 29, parentheses 1, which said that consent had to be obtained from any party with a lien, and that included the carrier and the special fund. So it wouldn't make sense to not allow one carrier to get the consent of the other carrier by court order. So clearly, the plain language doesn't always control in each case. So in this case, when you look at Section 15.4 and take the statute in consideration as a whole, you have to consider the language that Mr. Brockner was talking about in Section 15.3W, which is the conditions upon a non-schedule award are that it only is paid during the continuance of the disability, and there has to be a nexus between the disability and the loss of earnings, and that naturally would have to
Would you agree that the
end.
drafting of 15.4 is a little sloppy? That is, it would have been easier to say 15.3 accepting W?
Well, I think I pointed out in my brief that W didn't exist in 1920.
Yeah.
I believe it was U, so you have 20 sections or paragraphs that deal with schedule loss of use awards. Then you have this one catch-all phrase that says, oh, by the way, in other cases to which schedule loss of use awards don't apply, you have to look at the employee's earnings, lost time, whether the disability is continuing, whether the disability is the cause of the loss of earnings. And then when you take those factors into account, you decide if that award should continue or not. The statute itself even says that it's subject to change on the board's own motion or by the motion of either party. The amount of the benefits fluctuate. They can go up or down or stop completely during the course of a permanent partial disability that's a non-schedule as opposed to a schedule. So I think
So
it-
do you agree that a distinction should be made between the two types of awards? Because scheduled is guaranteed, where non-scheduled is contingent.
Yes, that's our position, of course. And the reason we say that is because that's what Section 15.3 says, so you're not bound by the language of Section 15.4 saying just subdivision 3 without distinguishing between the two. So I guess the other question is whether the 2007 amendments or this court's decision in Mancini changed anything. This court did say that one of the purposes of the 2007 amendments was to limit the disparity between the two types of awards. But that was in the context of what used to be lifetime award versus schedule loss of use awards, which are paid for a finite number of weeks. I don't think it was meant to eliminate all disparities between the two types of awards. In fact, this court said in the O'Donnell case that issues such as labor market attachment and showing that your loss of earnings is related to the injury is still necessary in order to receive that type of award as opposed to a schedule loss of use award. So I don't think that the 2007 amendments or this court's decision in Mancini dictate any different result. Thank you.
Thank you, counsel.
Good afternoon. May it please the court, my name's Louis Dower. I represent Kanye Khalid Green in connection with this claim, which piggybacks on the claim of his father, who's now deceased. Viewing this case, I believe, has to begin with the 2007 amendments to...
So, counsel, let me ask you that. If you were making this argument in 2006, would you win?
I don't know. 15.4 was there at the time, and said the same thing it says now. It says an award under subdivision 3.
It's a hard argument. I mean, the statute's been around for 100 years.
Now,
and-
what I will tell you is, had Mr. Watson, who was injured the same year the statute was amended, he was injured in late 2007 after the workers' compensation law was amended to cap the PPD benefits. Had he been injured in 2006, I would have told him, if he had asked me, how long are these benefits going to continue, I would have said, you're probably going to get $400 a week for life. And that would have been my answer. Now, after March of 2017, everything's turned upside down by the legislature. Non-scheduled permanent partial disability benefits are no longer capped, are no longer open-ended and last potentially for life. They are now fixed from anywhere from 225 weeks on the low side to 425 weeks on the high side.
Which is longer than this schedule awards, or no?
Oh, boy. A schedule loss of use award, the highest schedule loss of use award would be get your arm cut off, you get 312 weeks of compensation for 100% loss
And
of
the
use to the
low
arm.
end is,
It could be anywhere, 5% loss of use to the arm would be 15.1 weeks.
got it, okay.
Okay,
Thanks, sorry to-
and fingers, 15 weeks for a
I
pinky.
mean to quiz you on
uh,
at times.
That's why people love us comp lawyers.
So we were at the 07 changes.
So with the 07 changes, everything gets turned upside down. It's no longer a lifetime benefit. We have these caps, and I would point out that Mr. Watson, from the time he was classified until the time he passed away, he was working at two jobs, light duty. There was more than a $750 shortfall between what he was earning at the time of the injury, which was over $1,700 a week.
Do you
And-
agree that it could have fluctuated or been suspended during his lifetime as counsel?
Well,
argued?
absolutely. If his earnings would have increased, certainly. But because during the entire time he was receiving the benefits, the earnings information showed he was making, or there's more than a $750 gap between the pre-injury and the
So-
post-injury wages.
So with your agreeing that it fluctuates, for the sake of argument, if you said there were benefits allowed after death, how would you calculate them?
I think that the established rate of compensation that he had been receiving could be continued. And this is not an
But
unusual...
could be continued at what rate? That's the issue I'm having, right? So if these benefits could fluctuate and are variant during your lifetime, how do they suddenly crystallize into a lump sum upon death?
It wouldn't necessarily be a lump sum upon death, okay? But I believe the board could look at this and say, here's what the established loss of wage earning capacity was. Here is what the weekly benefit was based upon his earnings, and project that for the remaining cap weeks.
So that goes back to the contingency argument. Your adversary contends that these awards are contingent upon meeting certain ongoing requirements to collect the award. The fact that there might have been some period of time where all the ongoing requirements were met at a certain level certainly doesn't guarantee that those requirements would have continued to have been met through what he described, I think, as the ceiling time period for the benefit. It seems as if we have to have like crystal balls in order to determine what the appropriate post-death award would be.
That has been done in the past. Under Kelly v. State Insurance Fund, it was always projected that was limited by Burns, obviously, but in death claims and in permanent total disability claims, there's a projection of what the lost wage benefits would be and how long they would last in order to calculate the ATF deposit.
So
So,
it's an actuarial kind of
yes,
thing?
exactly.
And what would guide the courts? Is that information readily available to a court when they're making a determination of what the post-death award should be?
Actually, the board does have an actuarial unit that they do use to calculate ATF deposits. in non-scheduled PPD cases and death claims.
But if I'm understanding you, and correct me if I'm wrong, that is a guesstimate about the life of the individual, is that correct?
That's,
Okay, but
Yes.
that's not going to address the wage earning capacity, which is the other basis for fluctuation.
again, pre-Burns, when there was lifetime permanent partial disability benefits, those benefits were calculated, and the case law goes into painful detail onto how to calculate the, what was it called, the present value of the extinguished benefits because of the carrier's credit on the third-party net recovery.
And was it also an assessment of the actual market, the employability moving forward, and
No,
what the wages would be?
Basically, we would look at what the weekly rate of compensation was, and if the person was permanently partially disabled. In this case, Mr. Watson was working, and we used his earnings to calculate his benefit. In many cases with non-scheduled permanent partial disabilities, the people are out of work, and they receive a weekly benefit based upon the percentage loss of wage earning capacity. And that becomes a percentage of the two-thirds rate. So if somebody is 50% impaired, they would get 1/2 of two-thirds of their salary. And that would be then projected into
So
the
to
future.
be clear, is it your position, a slightly different question, that his son, sympathies to his son, is entitled to a lump sum, or again, sort of this installment until you reach the cap?
Well, the appellate division said they weren't making any determination on that. And I think, well, there's a couple of issues that come into play. There's no provision within Section 15 for the, or the, what was it, Section 23 that was amended to allow for the lump sum payment of the schedule. So I would say it would be payable over time because what if, God forbid, what if the son passes away? Okay,
Yeah,
and then there is no dependent. So you would,
Okay, so then what happens?
then the benefits would stop because there's no more dependents. Now, in this case, there was only, 21 weeks or so left on Mr. Watson's non-scheduled permanent partial disability at the time he passed away. And by the time this wound its way through the appeals at the Workers' Comp Board and the Appellate Division and back to the board, well more than those number of weeks had passed, so he did receive a lump sum payment at
Counsel,
that point.
there is no provision for a lump sum for non-scheduled awards, right? And you have one for scheduled awards.
Correct.
So they're treated differently. But isn't that also somewhat on the theory that you can calculate the lump sum payment easily for a scheduled award because it's never going to change? It's projected out over a certain number of weeks, whereas here it's subject to change based on these variables we've been discussing. So isn't the same principle of no lump sum applicable to no benefit after death?
I respectfully disagree and would answer.
I thought you might.
And would
Why?
answer no. And when you look at a schedule loss of use award, okay, that gets paid, a person gets 10% loss of use to the arm, 31.2 weeks paid at whatever the compensation rate is, and if they had less than that number of weeks of lost time while they were out of work post-injury, they get the balance owed to them. Now, there's also cases where the person may have been out of work for 40 weeks, in which case the disability would exceed the schedule loss of use, and they don't get any money as a result of the schedule loss of use award. So it's not always as cut and dry in terms of is it payable in a lump sum or isn't it? There's many cases where my clients have been out of work longer than the value of the schedule, so they don't get anything. Now, the thing is, as far as viewing the non-schedule and that there's no lump sum payment there, I do understand the court's concern with, well, how do you calculate it? And again, with somebody who's not out of work, or, excuse me, somebody who remains out of work is getting their percentage of their average weekly wage on that non-schedule award for the duration of the capped benefits. This case was a reduced earnings situation where Mr. Watson had continued to work at 2 light-duty jobs to help supplement his income. So that is a very long-winded answer to your question. Now, looking at the,
So if I'm understanding you on that one, you would say, in his case, you look at whatever was the benefit at the time of death, I think that's what you're saying. That's the benefit moving forward. So then if I'm understanding you correctly, under your interpretation, it doesn't mean that other claimants in Mr. Green's position would receive the cap, or they would always receive the cap? How does that work out mathematically? Is your rule that they always receive the cap? I guess that's the bottom line.
are you talking alive or dead,
No,
to put it?
posthumous.
Oh,
Let's
posthumous.
say we agreed
Well,
with you on that part.
Obviously, it depends on whether or not there is a dependent,
Well,
okay?
I'm
as-
assuming someone's going to receive the benefits, yes, there's a dependent, that's what I was saying, someone in the same position as, I'm sorry,
So
your
if there is
client.
if there is a dependent, then my answer to your question is yes, the balance of the non-scheduled PPD benefit should be paid based upon, again, the plain language of Section 15.4.
Was that the calculation that was done here? I think it was $19,000 and something.
Yes.
Was that based on the last benefit amount before death?
Correct, yes, that's 500 a week for those, I think it was 21 weeks or so. It was mentioned in your decision in Mancini about the, getting back to the 2007 amendments, to bring parity between non-scheduled and scheduled loss of use awards. So we have a situation where not scheduled loss of use awards, the injured worker really does not have to show any loss of earnings in order to qualify for that benefit. They get it whether they're working, not working, and that gets paid out to them and can be paid in a lump sum. And as you noted in Young, John, if there is a dependent, that entire award would get paid to that dependent. In this case, we have an injured worker who established a loss of earnings, a substantial loss of earnings of greater than $750 a week over the 320 weeks he collected his non-scheduled PPD benefits. And they were, set to end. And had he lived out a normal life expectancy, he died at age 55, which frightens me because I'm now 55 years old. What do you do after that? His loss of earnings, while he may have gotten raises or something like that, would presumably have continued, and pre-2007, he would have continued to receive those lost wage benefits. And here we have the legislature coming in and saying, well, we're going to cap these benefits. And in Mr. Watson's case, they were capped at 350 weeks because he was found with a 51% loss of wage earning capacity. If he was found with a 50% loss of wage earning capacity, we wouldn't even be here because you only get 300 weeks for a...
Counsel, in that legislative scheme, there was a disparity, and it required the legislature to come in and look at that particular issue, figure out, okay, for a non-schedule, we're going to give this certain amount of weeks, and, a uniquely legislative function here. And now it seems you're asking us to perform that type of feat and look at the statute and say, okay, as it's written, because these awards are different, we can't do this, but in fairness, we want to say you can recover this type of award based on a general idea of fairness. But that general idea of fairness didn't amend the statute. It was the legislature that amended the statute, and they did it somewhat surgically.
Except that the plain language of 15.4 is still there and doesn't differentiate between, and as somebody noted, they could have said except for awards under 15.3W, but they didn't.
Well, what about permanent total disabilities? Those aren't covered under 15.4. There's a lack of fairness there. Does the next case get to come in and ask us to apply the fairness gloss?
That I would believe. Well, what I would argue is with a permanent total disability, there you have an injured worker who's significantly disabled, does receive a lifetime benefit, but they do get the full 2/3 of their average weekly wage for the duration of time of their life.
And it
And
does-
it's a higher weekly benefit. I guess that's the,
Let's turn on what this award, I mean, his point is, or their point is that the award is extinguished. There is no award upon death. And that's why you can harmonize 15.4 and 15.3 the way they suggest. But the other one, because it's vested, right, the SLU award is vested, it's fixed, you're certain to get it, you either got it at the lump sum up front, or if you passed away, there's an issue about that lump sum, but in any event, that's the amount
No,
that would have been available.
I appreciate that position, but I believe it has to be looked within the context of the legislature taking away lifetime benefits
Yes.
for all the other non-scheduled permanent partial disability benefits, and those people that continue working at light duty and receive no compensation for that loss at all thereafter. Thank you very much.
Your honors have been talking about the rate. What would the rate be at the time of death? And nowhere can claimant point to where in the statute the legislature has provided any guidance for the board to calculate that rate. That is, and then claimant's attorney suggests use an actuarial table. That's what they do for aggregate trust funds. That's section 27. In there, the legislature says use an actuarial table. That's specifically authorized by the legislature to use an actuarial table. The legislature has provided no guidance to the board on how to calculate a posthumous non-schedule award in terms of the rate. It's true the board came up with a figure here, but it lacked any guidance on how to do so. It just felt it was constrained by the third department's ruling of the claimant gets the award, so it had to enter one. But again, it is up for the legislature to tell the board, because it has no guidance to date, on how to set a rate when there's no longer any loss of wage earning capacity caused by the disability, when there's no longer any continuance of the disability either. And so, and also one other thing is claimant kept calling non-scheduled awards before the caps a lifetime award. That they were not lifetime awards, they were not fixed, they were still contingent, as they've always been, as they still are, on there being of these ongoing requirements, which is continuance of the disability and also a impairment of the earning potential. And because those conditions cannot be satisfied upon after death, the non-scheduled award no longer exists, benefits can't accrue, and for that reason we ask this court to reverse the third department's decision.
Thank you.